My name is Matt Rose, and I'm going to talk to you about workplace investigations that have a criminal overlap. This may happen in a variety of contexts. Some common examples involve things like workplace theft, sexual assault, fights at the workplace. When these things happen, the employer is obligated to investigate and figure out what happened. But oftentimes, you'll have local law enforcement looking into them as well, as these may be crimes that require criminal prosecution. So when you're dealing with this situation, there's some important considerations to take in mind. So I'm going to give you 4 practical tips that you can implement to make sure you go through this process smoothly. The first one is that you should see local law enforcement as a potential ally. If they are investigating, they've probably gathered some useful information. They may have access to things you do not have. And at the very least, they may be willing to share that information with you if you reach out and try. Now, oftentimes, law enforcement will consider open investigations to be confidential, and they will not share anything with you. But at least you should try to gather information from them. At the very least, you can denote in your file that you've given it a shot. You can check off the box and say, I've tried. At the very best, you may get some information from them. Maybe they'll provide you some background information, maybe some documents. At the very least, they may be willing to share some things with you that they've disclosed publicly. In my experience, sometimes I've gotten really lucky and people have actually shared draft reports, some confidential information. And so if you hadn't tried, you'll never know. The other thing you should be aware of is that for a variety of reasons, police departments may not see an investigation to the end, or the local district attorney may not prosecute the case. Do not let that detract and derail your own investigation. You have to investigate, even if the police do not. Another thing is that as a workplace investigator dealing with a criminal case, you may have witnesses, parties, folks involved that have been through some serious trauma. These are not your run-of-the-mill situations. And if you're used to conducting investigations that do not have a criminal component to it, you may be surprised at how much that impacts folks. In a practical sense, you should be going into the investigation with a trauma-informed perspective. Be patient with people, spend the time necessary, ask open-ended questions, be willing to take breaks during interviews, be willing to break up an interview into 2 to 3 sessions rather than cram it all together in one. Be patient and be cognizant of how the trauma can impact the people you're involved in. At the end of the day, it may make the investigation a little bit longer. You may have to put in some more effort, but the end result will be better. The last practical tip is that there are different rights in different contexts. The best way to understand this is that in a criminal sense, people have the Fifth Amendment right not to talk to the police. In a workplace administrative sense, that right does not exist. So if you're going to do an investigation and you schedule an interview with someone, in the workplace, they have to show up. Otherwise, they could be fired. And the best way to understand this is to make sure that you vocalize this to the people involved and create some sort of record that the individuals in the work classification know that they have to show up, they are compelled, but everything they share with you as the workplace investigator cannot be then shared with the criminal investigators. It helps people understand the differences, and it can often put people at ease if they've decided that they don't want to get involved in the criminal sense, but they have to get involved in the administrative sense. Those are 4 practical tips. I hope they're useful. Thanks for watching. That's a wrap on today's VM Minutes.